Good morning and welcome to the Center for Constitutional Studies at Utah Valley University in Orem, Utah for day 2 of our annual First Amendment Conference. This year's conference is entitled Looking Forward, Religious Liberty Under a New Court. I'm Scott Paul. I serve here in the center as interim director and executive director. Speaking on behalf of my colleagues, we are thrilled to spend another day with you considering pressing matters of religious liberty. I extend a special welcome to the high school classes that are joining us today. 2 years ago, the Center for Constitutional Studies launched a K-12 constitutional literacy initiative, which includes, among many other things, bringing high school students to campus for special sessions of our conferences. Since the students can't come to campus, we've invited our high school friends to join us online for this session. They were also invited to join us for a special session yesterday. Please allow me just a few words of introduction and acknowledgement. Organized in 2011, the Center for Constitutional Studies is a nonpartisan academic institute that promotes the instruction, study, and research of constitutionalism. Our mission is to increase constitutional literacy in our local, state, and national communities in a nonpartisan manner. Speaking on behalf of my colleagues, I express gratitude to UVU Provost Dr. Wayne Vaught and UVU President, Dr. Astrid Tumines, for their support of our center. I also thank members of our advisory board for their invaluable guidance. Several of them were especially helpful in developing this conference. We hope that this is the last annual conference we hold entirely online for many reasons, not the least of which is that you miss out on engaging with the amazing students here in the center. Thanks to the generous support of the National Endowment for the Humanities, the Utah Federalism Commission, and especially the Wood family, the center is home to more than 20 phenomenal student research assistants. They are truly the lifeblood of our organization. Now, regarding our students, to our high school students watching, if you have an interest in government, politics, U.S. history, or the U.S. Constitution, consider coming to UVU and getting involved here with the Center for Constitutional Studies. We'll take good care of you. Now, it's my pleasure to introduce you to the moderator of this session. Matthew Richards is the chair of the First Amendment and Religious Organizations section of Curtin McConkie, Utah's largest law firm. Mr. Richards works collaboratively with business leaders and faith communities. He has a particular expertise in domestic and international religious liberty issues and has published articles and presented at international conferences on those topics. Mr. Richards has been recognized as one of Utah's legal elite and a super lawyer in multiple practice areas. He graduated magna cum laude from the J. Reuben Clark Law School at Brigham Young University and went on to clerk for the Utah Supreme Court. Matt is also a member of the advisory board here at the Center for Constitutional Studies. Matt, thank you for being with us today.
Scott, thank you so much for the invitation to be part of this and for the introduction. And special welcome to all those who are participating with us today, especially those of you who are high school students. We're excited to have you be part of our discussion. And I think that the topic of the topic that we're covering today in this particular panel is about religious freedom from the perspective of religious minorities. And this is an important topic for all of us. And that's true regardless of whatever faith you may have, or if you don't ascribe to a particular faith at all, because religious freedom is important. One of the things that I have loved over my years of studying religious freedom is a quote from the European Court of Human Rights that said that, in my own words, summarizing, it says religious freedom is indissociable from democracy because it provides a space where all of us can live out the lives according to the dictates that God speaks to our hearts. And that's important for each of us, regardless of our faith tradition. And I'm so pleased today that we have a chance to hear from people of many different faiths and traditions, and we can apply our own experience as we listen to what they have to say and to teach us. In fact, the religious freedom in the United States and around the world is often defined and expanded by the experience of minority faith. So some of the key cases that the United States Supreme Court has addressed over the years come from the experience of people on the fringes of society, and that's because those in majority religions tend to have political power to get what they want in communities and the way that the laws and expectations and the morals are set up. But those who are disenfranchised, those who don't have the ability to speak, often need to test them in the courts, and that's where we get these important decisions. I'm sure that we'll hear about those today. So you didn't come to hear me. Let me introduce our panelists today, and then we'll have a chance to hear from each of them for about 20 minutes, and then we'll have opportunity to ask questions at the end. So if you have questions, please put them in the chat. We're excited to hear from you, and we can have a discussion after hearing from each of the panelists. Today we're going to hear first from Asma Uddin. Asma I'm very pleased to have you with us. She is the author of several books and articles touching on this, including When Islam is Not a Religion, Inside America's Fight for Religious Freedom, and The Politics of Vulnerability, How to Heal Muslim-Christian Relations in a Post-Christian America. She's an Inclusive America Project Fellow at the Aspen Institute, where she's leading a project on Muslim-Christian polarization in the US. Ms. Uddin was formerly legal counsel at the Beckett Fund for Religious Liberty and has held academic fellowships at Georgetown, UCLA, Brigham Young University Law School. She is also an expert advisor on religious freedom to Organizations for Security and Cooperation of Europe and a term member for the Council on Foreign Relations. Welcome to you. We'll also hear from Mona Polacca. Mona Polacca is an educator, facilitator, and speaker, and she has held posts of responsibility within her community, such as treasurer for her tribe, which is the Colorado River Indian tribe. She's also a master in social work and justice at Arizona State University, and has over 30 years experience working, presenting, and publishing on health and social issues affecting Native American peoples. She serves as a tribal liaison for the Healing of the Border Project of Indigenous Alliance Without Borders, and is currently a senior fellow overseeing the Original Caretakers Program for the Center of Earth Ethics. As the president of the International Council of 13 Indigenous Grandmothers, she works with Indigenous women to preserve and protect Indigenous practices and ceremonies, including the right to use their earth-based medicine. She is a participant in the United Nations Permanent Forum for Indigenous Peoples Issues, and she has assisted in listening sessions with Indigenous peoples. In 2013, at the Permanent Forum, she and others presented an intervention, a call for the Indigenous Women Forum on Water and Peace. And her efforts have included providing support for First Nations to build capacity to take action on climate change, build sustainable communities, protect lands and waters, and conserve biodiversity. Her spiritual practice is grounded in the Havasupai, Hopi, Utiwa original instructions and the Native American Church. And then finally, we're excited to welcome Dr. Michael Helfand. He goes by Abby and is an expert in religious law and religious liberty. A frequent author and lecturer, his work considers how the state treats religious law, custom, and practice. He's a professor of law and vice dean for the faculty and research at Pepperdine Caruso School of Law, as well as interim director of Pepperdine's Law Note Bar Institute on Law, Religion, and Ethics. Dr. Helfand is also visiting professor and Oscar Rubenhausen Distinguished Fellow at Yale Law School and a senior research fellow at the Shalom Hartman Institute of North America. He received his Juris Doctorate from Yale Law School and his PhD in political science from Yale University. His academic articles have appeared in numerous law journals, including Yale Law Journal and the New York University Law Review. Professor Helfand is also often provides commentary on clashes between law and religion, writing for various general audience publications such as the Wall Street Journal, the Los Angeles Times, USA Today, and others. Welcome to all of you. And Asma, we'll begin with you.
Well, thank you. Thank you, Matt, Scott, and Utah Valley University for inviting me to speak today. This talk actually comes at a great time. My new book, The Politics of Vulnerability, was released just yesterday, and I'm really looking forward to talking with you guys about it today. But before I get to that, I'm actually going to talk about the first book that Matt mentioned, which came out in 2019, and it is titled When Islam is Not a Religion: Inside America's Fight for Religious Freedom. And I went on tour with this book and was traveling all over the country with it for 9 months before the COVID-19 shutdown brought it to a close. And then I took everything I learned from that tour and I put it into my second new book. But before I get to that, what is When Islam is Not a Religion all about? The title may be confusing, maybe even bewildering, but so is a claim that gave rise to it. And that claim is that Islam is not a religion. It is instead a dangerous political ideology, and therefore Muslims do not have rights under the First Amendment. Increasingly, we hear arguments made both in the courts of law and the courts of public opinion that Islam is not a religion, that it is instead a dangerous political ideology that's just hell-bent on taking over the United States. Islam is an almost otherworldly bogeyman in this sort of narrative, a larger-than-life, all-consuming swamp creature. And in the process of stopping it, its opponents run roughshod over the human rights of everyday human beings who happen to be Muslim. So consider some general statistics on the rise of anti-Muslim sentiment. Almost 1 in 5 Americans believe that under the US Constitution, American Muslims do not have the same rights as other American citizens. And Americans favor protecting religious liberty for Christians over other faith groups, ranking Muslims as the least deserving of this right. 82% voted in favor of protecting religious liberty for Christians, while only 61% said the same for Muslims. The general climate of anti-Muslim bias correlates with a sharp rise in hate crimes. Anti-Muslim hate crimes are the fastest growing religious hate crimes. In addition to these hate crimes, more than 42% of Muslim children in grades K through 12 have experienced some type of bullying because of their faith. And all this is made worse because it happened at a time when the country's top leaders were all trumpeting the importance of religious freedom. During the 2016 presidential election, almost all of the Republican presidential candidates positioned themselves as the ultimate defenders of religious liberty. Candidate Trump promised on the campaign trail that the first priority of my administration will be to preserve and protect our religious liberty. And when he was elected, former President Trump did indeed make it a top priority. He opened the Conscience and Religious Freedom Division of the Department of Health and Human Services, issued broad religious liberty guidance, and instituted the Religious Liberty Task Force at the Department of Justice. And then for the last 3 years, the State Department held a multi-day ministerial to advance religious freedom and issued a declaration reasserting the United States' unwavering commitment to promoting and defending religious freedom. But every single one of these measures was in response to the demands of a particular religious group, conservative Christians, and they all took place right alongside a growing climate of anti-Muslim sentiment and hate crimes, and the growing salience of the claim that Islam is not a religion and Muslims don't deserve religious liberty. In fact, even during the 2016 presidential campaign, the presidential candidates were rallying for religious freedom, but they were also proposing staunchly anti-Muslim measures. Trump promised to establish a database to track Muslims and suggested shutting down mosques, and Ted Cruz advocated for surveilling quote-unquote Muslim neighborhoods. Other presidential candidates chimed in too. Ben Carson declared that a Muslim absolutely could not be president, and Rick Santorum said the US Constitution does not protect Muslims because Islam, quote, is different from Christianity. One BuzzFeed report found that since 2015, Republican officials in 49 states have publicly attacked Islam, some even questioning its legitimacy as a religion. Things like an Oklahoma state representative calling Islam a cancer and requiring his Muslim constituents to fill out questionnaires asking whether they beat their wives. The same lawmaker has also said that Islam is not even a religion, it is a social political system that uses a deity to advance its agenda of global conquest. A South Dakota state senator who was then running for the US House of Representatives questioned in an official press release whether the First Amendment applies to Muslims. A 2014 Republican congressional candidate and now congressman from Georgia wrote in 2012 that, quote, Islam would not qualify for First Amendment protection since it is a geopolitical system. And in July 2019, the founder of the Western Conservative Summit and a former Colorado Senate president stood on the summit stage under a banner proclaiming the importance of religious liberty and said, "The simplistic approach of simply granting unconditional freedom of religion to a religion that doesn't believe in freedom, and never doubt me, Islam does not, that approach is civilizational suicide, friends." The obvious contradiction between his desire to protect religious freedom and his advocacy against Muslims' rights seemed to elide him. A friend of mine who works with state legislatures to form bipartisan religious freedom caucuses affirms that BuzzFeed's findings reflect a general trend. He told me he estimates that approximately 5 to 10% of state lawmakers hold to some version of that Islam is not a religion belief. None were known in advance to be what he calls bomb throwers, who he said he generally avoided at that point anyway. So you have a set of lawmakers, a bunch of sort of really extreme folks that he kind of avoided, and then the non-extreme folks, among which he said 5 to 10% of those lawmakers actually hold some version of this idea that Islam is not a religion and that Muslims do not deserve religious freedom. And it's not just politicians. Many commentators have noted a lopsided approach to religious liberty at the US Supreme Court. For example, many have noted the difference in how the court approached anti-religious hostility in a Christian case versus a Muslim case. The first, decided on June 4th, 2018, was Masterpiece Cake Shop v. Colorado Civil Rights Commission. Masterpiece involved Jack Phillips, a Christian baker, who refused on religious grounds to bake a wedding cake for a gay couple. The court ruled 7-2 in favor of the Christian baker, holding that the Colorado Civil Rights Commission, in reviewing the gay couple's complaint against the baker, had treated religion with overt hostility, at one point even comparing Phillips to Nazis. This, the court held, was unacceptable. Religion under the US Constitution cannot be treated with so much contempt. The court said the commission's hostility was inconsistent with the First Amendment's guarantee that our laws be applied in a manner that is neutral toward religion. And yet, just 3 weeks later, the court's majority upheld the travel ban despite evidence of prejudice far more egregious than the evidence in Masterpiece. For those of you not familiar with the case, it involved a challenge to Trump's Executive Order 13769, which blocked citizens from 6 majority Muslim states from entering the US. To many Americans, the travel ban was an extension of Trump's long history of anti-Muslim bias. As a layperson in 2011, he tweeted that the Quran teaches tremendous hatred, which absolutely creates a quote-unquote Muslim problem. When he ran for president, he made the Muslim problem central to his campaign. In December 2015, he praised an author for acknowledging quote-unquote Muslim problems. He later declared, "I think Islam hates us," and then backed up his statements with policy proposals such as a total and complete shutdown of Muslims entering the United States, warrantless surveillance of American Muslims, closing American mosques, and creating a registry of all Muslims in the US. So this was a backdrop of the travel ban, and there was plenty of reason to conclude that it was based in anti-Muslim bias. But the majority of the court decided instead to defer to the president. For many commentators, the conservative justices who spoke so passionately about anti-Christian bias seemed not to care much when the bias was against Muslims. And then in February 2019, another case made many Americans wonder, in the words of the New York Times editorial board, is religious freedom for Christians only? Alabama executed Dominic Ray, a Muslim death row inmate, without accommodating his request to have an imam in the room with him. The clergy permitted in the execution chamber were limited to the ones on staff, but the prison employed Christian clergy only. Ray challenged the prison's denial on religious liberty grounds. His case made it to the US Supreme Court, which ruled against him and permitted the execution to proceed without the imam. Outside the Supreme Court, legal challenges to Muslims' religious rights are common, especially in the area of religious land use, which is like the ability to build or expand houses of worship and other religious facilities. Perhaps the most egregious example of this is a 2010 case challenging a county approval of building plans for a mosque in Murfreesboro, Tennessee. According to the mosque opponents, Islam was not a religion, and therefore the mosque construction plans did not get to benefit from any of the county or federal laws that protect religious organizations. The Islamic Center of Murfreesboro was unique in that the arguments were actually made in court, but in just about every other scenario where a local Muslim community is trying to build or expand a mosque, they are faced with strong public backlash, much of it centered on this idea of Islam not being a religion. And my contacts at the US Department of Justice have confirmed that this argument comes up in pretty much all of their mosque or Muslim cemetery cases. In the Murfreesboro case, the judge permitted a 6-day hearing in which the plaintiff's attorney literally put Islam on trial. And the DOJ had to file an amicus brief explaining that, quote, under the US Constitution and other federal laws, it is uncontroverted that Islam is a religion and a mosque is a place of religious assembly. The argument that Islam is not a religion also undergirds efforts to prevent Muslim religious arbitration. And finally, in the book, I also discussed the problem of judicial biases and the empirical evidence that Muslims, more than any other religious group, face biased judges. Beyond these examples, my book also looks at other limits on religious freedom, not just for Muslims, but for religious minorities more broadly. I also spend my last chapter on today's culture wars, which have pitted religious freedom against sexual freedom. There, I assess how those cultural wars intersect with Islamophobia or anti-Muslim sentiment. Now, when you get to that chapter, this is the last chapter of my previous book, you'll learn that I have litigated and otherwise advocate in support of various conservative Christian claims to religious freedom. I was part of the legal team supporting Hobby Lobby in its case at the US Supreme Court. For those of you who don't know what that case was about, it involved the Hobby Lobby craft stores owned by a fundamentalist Protestant family that objected to covering 2 forms of contraception in the employee health insurance required by the Affordable Care Act. The 2 drugs were the morning after and week after pills, which the Hobby Lobby owners said constituted abortifacients and thus violated their religious beliefs against facilitating abortion. The public response to this case, as with many high-profile cases brought by conservative Christians, was that the religious believers were anti-women, backwards, and a threat to all Americans. Now, the fact that I advocated on behalf of conservative Christians does not necessarily mean that I have any particular sympathy for their religious claim. Instead, I recognize quite simply that I don't have to agree with their beliefs in order to protect them. We can and should protect each of our rights to be wrong. As I learned on my book tour, it was precisely this consistency and integrity in my defense of the principle that opened up the possibility of exchange with many conservative audiences. Remember, my book laid out in detail the ways many conservatives say and do things that hurt Muslims' rights. So why would they invite me into their spaces to tell them about it? In our divisive, tribalized world today, that's exactly what does not happen. We retreat into our safe spaces and block out anyone who thinks differently from us. We not only see these people as wrong, but at times even see them as evil. So why were my exchanges different? I was absolutely fascinated with this question and started to probe. My conclusion in many ways was simple. Unlike others who criticized their statements and actions, I was coming to these conservative audiences from a place of compassion and consistency. First, I talked to them about their concerns. I cared to engage them and not dismiss them. Instead of saying their religious claims were invalid or mere pretext for bigotry, the oppression of women, and any number of other judgments leveled at conservatives these days, I said, I understand. Your claims are motivated by a sincere religious belief. You are genuinely worried about your ability to live according to those beliefs, and you're not a bad person because you feel that way. And then I told them, look, I'm sticking up for you, even as I call you out for your hostility against Muslims, and in return, I expect you to stick up for my community. I use the language of religious liberty to argue my case, and I saw time and again an opening, a receptivity to listen and be in conversation. So I had these basic observations about the psychology of my conservative audiences, and I wanted to write about it, but I felt that I didn't have the right words to describe what I was seeing. And then my friend, a political scientist, introduced me to the scientific literature on group identity, intergroup bias, and the many studies that look at these things in relation to religion. Suddenly, I had the words I needed. I had a framework, and I set out to write my next book, which came out yesterday, The Politics of Vulnerability. At the core of my thesis is the idea that we are all human and we all act and react in very human ways. First, there is group identity. Our group is the in-group, and those outside our group are the out-group. Our attachment to our group is so significant that the loyalty actually boosts self-esteem. And on the flip side, studies have shown that if we're isolated from our group for whatever reason, the stigma acts on us psychologically and also triggers a physical assault on our body. What this means in practice is that even evolutionarily, humans are programmed to signal their allegiance to their tribe as a way of avoiding this loneliness and stress that comes from being cast out. And second, there's a mechanism of intragroup bias. While it's natural and not harmful for groups to favor their own group, things get a lot more complicated when the in-group starts to experience really strong emotions. Strong emotions include things like feeling the out-group is moving against you, An out-group seen as threatening may elicit fear and hostile actions. Whereas high status groups, or groups that are a numerical majority and have power, don't feel threatened by minorities. When the status gap is very wide, they are more likely to feel threatened when the status gap is closing. And in fact, the status gap is closing. If we're going to think of white conservative Christians as the in-group that feels threatened, there are many reasons why they feel this way. First, and for the first time in US history, white racial dominance is on the decline. In 1965, white Americans constituted 84% of the US population. Since then, there has been influx of immigrants, with nearly 59 million arriving in the last 50 years alone. Between 1965 and 2015, the American Asian population went from 1.3 million to 18 million, and the Hispanic population went from 8 million to almost 57 million. And now Pew says whites generally will be a minority by 2055, and the US Census says it'll happen even sooner in 2044. And second, also for the first time in US history, white Protestant Christians are a minority in America. A 2017 study found that the white Protestant Christians constitute only 43% of the US population. And to understand the gravity of the shift, consider that in 1976, 8 in 10 Americans were white Christians, and 55% of Americans were white Protestants. In 1996, white Christians still made up 2/3 of the population, and today they don't even constitute a majority. And third, the demise of white Protestant America has brought with it an end to the cultural and institutional world built primarily by white Protestants that dominated American culture until the last decade. Not only is Christianity declining, but so is religion overall. More and more Americans are religiously unaffiliated. And in 2019, the percentage of these unaffiliated became roughly the same as the percentage of evangelicals or Catholics. So altogether, this has precipitated an internal identity crisis that has generated tremendous anger, insecurity, and anxiety. And unfortunately, that anger has been directed towards a number of minority groups, including Muslims. But intergroup bias studies don't just tell us what causes a bias, they also tell us how to solve that hostility that manifests when the in-group feels threatened. And a big part of that solution is empathy. In our increasingly tribal society, each side has its own stories of oppression and victimhood, but tribalism makes conversations about these issues harder because it robs individuals of their humanity and reduces them to members of in-groups and out-groups. And to build connection across difference, we have to be willing to be intentionally with people who are different from us and learn how to listen, have hard conversations, and be more curious than defensive. So speaking purely pragmatically, if we mock or berate conservative Christians for feeling threatened or persecuted, we'll succeed in just making them feel even more threatened, and this in turn will lead to more hostility. So in my book, I talk about empathy as a concrete tool for conflict resolution, but more importantly, I demonstrate empathy in the way that I talk about the concerns that conservative Christians have, as they say, show, don't tell, and I guess I do both of them in my book. I write in a way that communicates how I see others, even those who might engage in hateful acts against my own religious community, as humans. And when I do that, I create openings for real change and real conversations. Thank you.
Thank you so much, Asma. We're so grateful for your review of those books that you've written. It makes me interested. I can't wait to talk more about this, but we'll turn the time over now to Mona Polacca for her presentation.
Thank you. First of all, I'd just like to greet each and every one of you. Good day. I'm grateful to be here, and also like to acknowledge the First Nations and the ancestors of all of the places where we are now speaking from. Myself, I am in Tucson, Arizona. I'm on the traditional lands and territories of the Tohono O'odham Nation. And I am, on my mother's side, I'm from the Havasupai people down at the bottom of the Grand Canyon, the people of the blue-green water, guardians of the Grand Canyon, and Hopi and Tewa Pueblo people of northern Arizona. And in our traditional ways, one of the things that we always speak from is our identity of who we are and where we come from. As part of my identity is the water. I come from this water, the blue-green water of down in the bottom of the canyon, but I'm also from the Colorado River. And so the way we think about it, it is that everyone that is along the river, that body of water, are my relatives. All of the ones that are within the water are my relatives. And so I acknowledge that that connection. And I'm coming as a Native American, speaking about our religious, or what we usually don't call it religion, but we call it our spiritual practices and beliefs. And the question I'd like to give to you to think about is for you to think about this this First Amendment, the First Amendment of the U.S. Constitution, which protects the freedom of speech, religion, and the press. It also protects the right to peaceful protest and to petition the government. But at this time, it has many interpretations, and there's also been many disputes related to it. And what I would like to mention is, for yourself to reflect on that. Reflect on how are you connected to this in your spiritual or religious practices. I'm speaking from my experience and the historical experience of the Native American people, the original people of North America. And we, as the Native American people, or also referred to as American Indian, we did not receive our rights for our freedom of religion until 1978 from the American Indian Religious Freedom Act. And it was this act then that gave the indigenous people of North America the right to practice our traditional spiritual beliefs and practices. It was against the law for us to do that. Our people, once they were found to be practicing their spiritual ceremonies, they were jailed, they were beaten, they were persecuted. And so we, as the Native Americans, the first people of our country, the United States, did not have that right. But I'd also like to mention that in the U.S. Constitution, there is a special provision in there that speaks to how the United States would interact with the tribes in the United States, and that was the I believe it's called the Intercourse Act, which related to how people would interact with the tribes. And there's another piece in there that also speaks to our relationship and that how the United States Constitution upholds any treaties that the country engages in with other nations. And the tribes of the United States, the tribes that were within the boundaries of the United States, were included in that. And so what that established was that tribes have what is called, or often referred to as, the government to government relationship, that tribes are nations within this nation, and that there were treaties that were entered into throughout time, and that those treaties are considered part of the supreme law of the land. And so I'm not going to get into explaining all that. That would be a good thing for you to look at in terms of our US Constitution. Even though we have this relationship with the United States, we have not enjoyed the honoring of this relationship, the honoring of our treaties being upheld and honored and fulfilled according to those agreements that the United States have entered into. And so when it comes to our freedom of religion, there are certain things that I think are important for the general public to be aware of. When we received our freedom of religion, there were many of our tribal nations leaders, spiritual leaders, medicine people that advocated for this, that went and testified, that spoke, and took great lengths in order for us to be granted our freedom of religion. And and so in their efforts, part of that act gives us the right to be able to have our paraphernalia, our sacred ceremonial items. And one of the sacred items that we use in our ceremonies are eagle feathers. And eagle feathers are a treasure to us. They represent an honor. They represent our sacred connection with the Creator. We use them for a blessing. We use them to clear our path. We use them to hold our balance and be grounded physically, mentally, spiritually, and emotionally. And so we have that right to have possession of eagle feathers. And in having that right, in this law, it says that we are the only ones that would have that right to hold these feathers. But in order to have that right, we have to be a member of what's called a federally recognized tribe. And these are tribes that the government, the US government, has established this relationship with, as could be through treaties and different agreements that were made, that gave us this federal recognition by the government. And there's over 500 tribal nations in the United States that have this recognition. There are many more tribes, but they are not federally recognized. They didn't seek recognition. So, but they are still tribal nations. They still have their homes, their traditional lands, and continue to live where they traditionally have lived from time, we say time immemorial. So, so we are able to have the eagle feathers. The other right that we were given was the right to have our earth-based medicine. Our earth-based medicine are the various kinds of herbs that we use in our ceremony or in taking care of ourselves physically, mentally, spiritually, and emotionally. And one of those in particular that is included in that American Indian Religious Freedom Act is peyote. And so only Native American people, according to this act, are legally able to possess and use peyote. And part of that use of the peyote is within the Native American church. And so, so in order to be in line with that act, again, you have to be a member of a federally recognized tribe. We also have, we as American Indians, we have what they call, we have a certificate of Indian blood, which is sort of like our certificate of pedigree. And it states this, this certifies that Mona Polacca is a member of the Colorado River Indian tribe. She is Havasupai, Hopi, and Tewa. And she's 4/4 Indian. That's my pedigree. I'm 4/4. I'm full-blooded Indian. And so I have this card. We also have a card that we carry if we're going to be carry any of our paraphernalia, our eagle feathers or other instruments that we use, our medicine, like the peyote. If we have possession of the peyote, we have to have a card. And so, so these are some of the requirements that we as First Nations of the United States comply with. And we, when that act was passed, we agreed to do it. And so that's what we do. We uphold the honor of our relationship with our spiritual practices and beliefs and all of the things that go along with it, which include places like this place I'm in front of, this water, this place, this ground here, the earth. We hold that in a very, very, very sacred and special manner. And so under this law, we stand behind that and we uphold it. One of the things that have been occurring is in relationship to these rights that our people, the elders, the ones before me, stood up for and fought for, are now being put in a position where the non-native people are saying, give it to me, give me that right, give it to me, I want it, I deserve it, I have the right to have what you have because of my religious freedom. And so this is something that needs to be considered and thought about. The historical efforts that are made and have been made in regard to the American Indian Freedom, the American Indian Religious Freedom Act are very, very specific to our people. There is a history that we have in connection to these things that we use, even the places where we have the ceremony. We have a relationship with that. And so the other thing that comes up when we talk about our spirituality, our religious beliefs and practices is culture. Culture is defined as being, is defined with our relationship, or it means having traditions, beliefs, practices, life ways, art, crafts, and social institutions of my community, our community, and our Indian tribes, or even any local ethnic group. And so whenever we talk about our existence as tribal nations, we always include culture. And part of the reason why we include culture is because it's our practice and our way of life. It's our way of doing things that maintain our sense of identity. And just like this water here, that's my identity. I come from this water. And so I value it, I treasure it, I hold it as sacred. And so when it comes to our people, the indigenous, the Native American people, those are some of the key things that we always will mention. And we also mention our relationship with what we call the sacred foundations of life. And the sacred foundations of life is not anything different than any one of you here in this audience. The sacred foundations of life are the water. We lived inside water in our mother's womb. That was a very special place. It was sacred. That's where our life began. So we always acknowledge the water as our mother water. It's a sacred element. It's life. That's why you hear people saying that now. Water is life. And that's acknowledging it, acknowledging ourselves. And then the air you breathe, the air we breathe, that's our life. We acknowledge it and give thanks to it. And then the sun, the fire, we call the sun is like we call it our father. And it gives life too. We depend on it. And then our Mother Earth, the earth we walk on, the one that gives us life. Those four elements, we call them our sacred foundation of life. And so And so then that also is how we acknowledge and recognize, honor, and respect a place like this place where I'm from. It's home. If you could sit in front of this kind of water, this water here, and maybe there's a place where you go to, beautiful lake, river, stream, spring. Maybe there's a place like that that you go to, and it gives you this beautiful, wonderful sense of life. And you could look around you and you see the plant life, the animal life, all of this beauty of life that are also part of us. And you get that feeling. Maybe you don't think of it as a sacred feeling. Maybe you don't think of it as a spiritual feeling, that these things have a spirit that you feel. That's what we could say, we feel the spirit of the water. You can feel the spirit of the water in the air when it rains, or the mist coming off the waterfall. You can feel it, how it makes you feel. Same thing with air, fresh air. Same thing when you go out into the sun and it's nice and warm. The same thing as you walk on the Mother Earth, or you pick a fruit off the earth and you can eat it. That relationship, you can hopefully understand. That's what we're talking about when we say it's sacred. That's what we're talking about when we say we have a spiritual connection that is what we call our spiritual practice and belief. And there's certain motions, certain things you do, certain things you offer. My mother told me, when you come upon water like that, when you come upon the water in its natural state, you go to it and you put your fingers in it and you rub your hands together and you touch your heart and touch your mind. You introduce yourself to it. And then you can go ahead and use it. Take some or get into it. You go ahead and do that. That acknowledgement again. That's how we talk about. That's why we say it's sacred. I'm talking about this because that's one of the I believe one of the biggest barriers that we face when we have to go into a court of law that is not of our culture, not of our worldview, not of natural law, but of man-made law. We follow the natural law.
Ms. Polacca, thank you so much for sharing your experience with us. We're so grateful for you and for your perspective. And I look forward to the questions that we'll have for you in our discussion in a few minutes. It's time to turn the time over to Dr. Helfand, who will share with us his perspective. Avi.
Thanks so much, Matt. Really appreciate the introduction, and UVU for hosting. Really a pleasure to be here today. Let me tell you a little bit about what my plan is for the next 20 minutes or so. So my plan is I'm going to try to give you the perspective of American Jewish institutions with respect to religious liberty. And the way I'm going to go about that is I'm going to try and tell you a history of how American Jewish institutions advocated in religious liberty cases through the amicus briefs that they filed. What's an amicus brief? In any court case, you have two parties, typically, sometimes more, A versus B. But sometimes the decision a court's going to make in a particular case also implicates C. And as a result, this third party sometimes will come to the court and say, we also would like to file a brief because what you're going to decide today implicates our interests as well. And as a result, we'd like to tell you some things about the case, about the law, that we think it's important for you to know. And over the years, American Jewish institutions have filed maybe, there's some statistical data on this, as of the early 90s, more than any other faith community in the United States. I'd like to use those documents to try to tell you the story about how American Judaism has viewed religious liberty through the years, how that's changed over time, maybe even a little bit of a theory as to why it's changed over time. And in that way, my goal is to tell you a little bit about the history and the future of religious liberty as seen through the eyes of American Jewish institutions. Okay, so let's start with a little more background. So first thing we have is free exercise doctrine, religious liberty doctrine, free exercise of religion, one of the two religion clauses in the First Amendment. You know, part of this story has to do with the ways in which religious liberty law and doctrine, which I'm sure you've talked about already at the conference, has evolved over time. There have really been three stages, so to speak, of how religious liberty has worked in the United States. The question always is, what is the trigger for a religious liberty claim? And then what does the government need to prove if it wants to say, we get you have a religious liberty claim, but we have something that trumps your claim? And before 1990, the way this worked was the following. The trigger for a religious liberty claim was a substantial burden on religion. I'm not going to say a ton about what that means right now, but some sort of burden on religious practice. And the government could trump a law if it enacted some sort of law, state or federal government, a law that substantially burdened religious exercise in some way or another. The government could still justify that law if it was the least restrictive means to accomplish a compelling government interest, or as I like to say sometimes in human terms, the only way to do something really important. That was before 1990. And as I'm sure you've discussed, at some point in 1990, the Supreme Court changed the trigger for what constitutes a religious liberty claim. It changed it to a law violates the free exercise clause only if it targets religion. So if you have a law targeting religion post 1990 under the First Amendment, what would happen is that law would be unconstitutional unless, again, the government could prove it was the only way to do something really important. 1993 comes along and Congress says, we don't like this new version of the law, this new only targeting religion, as opposed to any time a law merely burdens or substantially burdens religion. We don't like the way in which you've restricted, Supreme Court, the free exercise of religion. And so under a federal statute, Religious Freedom Restoration Act, we're simply going to say no. We want to go back to the old standards. Then there was a debate. Does this apply to federal law? Does it apply to state law? The Supreme Court intervened. Other states enacted. I don't want to get into all the doctrine. Here's what I do want to focus on. What I want to focus on is what I said at the outset, that there's always a trigger and then there can be a justification, something that will trigger a religious liberty claim, some debate. Have you triggered a right to religious liberty in a particular case? And then if you have proved that as a plaintiff, the government can then justify that religious liberty imposition on religious liberty by showing that it's the only way to do something really important. I want to use those two categories to show the way in which arguments lodged by American Jewish institutions over time have changed. They've shifted from broad consensus within the American Jewish community at the outset over religious liberty to debates within the American Jewish community as to questions on the margin. Could there be a justification for an imposition on religious liberty? That second category. Is it the only way to do something really important? And then to a third stage, a stage I think we live in now where there is growing dissensus, the opposite of consensus, growing dissensus within the American Jewish community over how to deal with claims at their core, whether or not we can agree that there's an actual religious liberty claim, even before we talk about whether or not the government has a justification for imposing some sort of burden or the targeting of religion. How are we going to do that? Well, I just told you, here's kind of what the world looks like from the perspective of these amicus briefs. In the 60s and 70s, what you saw within the American Jewish community was broad support of religious liberty claims. But as you moved into the 80s and 90s, you began to see division at the borders of the doctrine. And I'll give you examples soon. And now we have entered a phase where within American Jewish community, you have growing dissensus over the quality of the claim itself. And so let me try and put a little meat on the bones to give you a sense of what this story looks like. Let me tell you, begin with the story of consensus. Early on in the 60s and 70s, you had a couple of religious liberty claims that went to the Supreme Court, cases over Sunday closing laws, something that used to exist in almost every jurisdiction where businesses could not operate on Sunday, and Sherbert v. Werner, a case that has to do with unemployment benefits for somebody who was terminated for not working on Saturday, and Wisconsin v. Yoder, a case about compulsory education laws in Wisconsin, where an Amish family said they could not send their kids to school in compliance past elementary school and middle school, because it felt so doing, sending them to public school would ultimately harm their kids, undermine their religious values, and thereby undermine their religious community. Those are the three kind of big cases in this first phase, 60s and 70s. And in all these cases, American Jewish institutions offered robust support for these religious liberty claims. You know, the first case, the Sunday closing laws, was actually filed by Orthodox Jewish merchants. And these Orthodox Jewish merchants said, listen, we have this problem. If you, government, require us to be closed on Sunday, and we're also closed on Saturday, our Sabbath, because of our religious conviction, we have a problem. We're closed 2 days a week. Our competitors are closed 1 day a week. And that presents a economic disadvantage for us. And all American Jewish institutions supported these claims. Here I have the Synagogue Council of America, used to be the umbrella organization for all the different streams of American Judaism: Reform, Conservative, Orthodox, Reconstructionist. The Synagogue Council of America, along with the Jewish Council for Public Affairs, another umbrella organization, many Jewish institutions in the United States. Actually, back in the 60s, it had a different name. It's now called the JCPA. All of these organizations said, listen, this is a problem. You're imposing a heavy burden on the adherents, upon their adherence to their religious beliefs. No good. The Anti-Defamation League and the American Jewish Committee on the right side of the slide, two of what are in American Judaism called the Big Three, the Anti-Defamation League, the American Jewish Committee, and the American Jewish Congress, similarly filed an amicus brief in support of the suit. And saying, again, you're imposing an economic penalty on Jews who are adhering to their Saturday Sabbath. As an aside, the Orthodox Jewish merchants lost the case for reasons that are interesting, maybe something that we'll discuss together another time. In a similar way, in Wisconsin v. Yoder in 1972, Jewish groups from across the ideological, denominational spectrum again supported the Yoder's claim that they should not have to abide by compulsory education laws because of the threat it presented to their religious way of life. On the left, again, the Synagogue Council of America, that umbrella organization of all the rabbinical arms of American Judaism, the American Jewish Congress, maybe one of the biggest powerhouses in religious liberty litigation, or I should say church and state litigation in the 50s and 60s, all noted that this was deeply problematic, that you could only trump religious liberty if you had some sort of incredibly compelling reason for doing so. And on the right, the National Jewish Commission on Law and Public Affairs tied this into a concern more broadly that you were seeing a tide, an increasing tide of government hostility towards religious nonconformists. And in this way, once again, every brief filed by a Jewish institution, every amicus brief, every third-party brief filed supported the claims of the Yoder family, the plaintiffs in the case. Now, that's the 60s and 70s. When you get to the 80s, I don't want to oversell this point. You begin to see division. It's not division all everywhere. This is a quick slide to give you a flavor for it. The 80s were quite the party when it came to religious liberty. Tons and tons of cases started popping up before the Supreme Court for reasons that are interesting. But here, in all these different cases, different fact patterns, you once again had all Jewish institutions filing on behalf of, filing amicus briefs supporting the claims of religious claimants. And so you still have pretty broad consensus. Hopefully this slide even, gives you a good sense of that. And yet, cracks begin to surface in the 1980s within American Judaism. And let me try to give you two examples of these cracks. The first is a case, presiding bishop of Church of Jesus Christ of Latter-day Saints v. Amos. This is a case from 1986. 1986, a particular institution in Utah, LDS institution in Utah, terminated the employment of an employee because he did not receive a temple recommend. And the employee filed suit, and the institution said, it's okay that we terminated this individual on religious grounds, even though typically in employment, religious discrimination is impossible. But Title VII, which is what provides under federal law protection to employees from religious discrimination, has an exception for religious institutions. Religious institutions are allowed to impose certain kinds of religious standards in when it comes to questions of employment and terminate people who don't meet those standards. And actually, the institution ends up winning the case. But what's interesting is the way in which Jewish institutions responded to this case. By and large, I would say Jewish institutions supported the LDS institution, the Deseret Gymnasium, in this case, saying that it makes perfect sense for Congress to enact a law like Title VII and provide an exemption for religious institutions. Providing religious accommodations to religious institutions is as American as apple pie. So claimed most of the Jewish institutions that filed third-party amicus briefs in this case. But you do get one brief from an organization, one of the big three, the Anti-Defamation League, that began to worry about the idea of providing accommodations. The idea of providing accommodations was problematic in their view because of the way in which it gave this unyielding weighting in favor of religious employers, almost that a religious employer could trigger this rule and thereby impose penalties or harms on a third party. And on this logic, the Anti-Defamation League argued that this started looking less like a religious liberty claim and more like we have a separation of church and state problem. The idea that a religious employer would wield such power and such authority, they thought started to look like a breakdown in the wall of separation between church and state. As I said, this view didn't win the day in the case, but it's interesting that you begin to see this claim that separation of church and state worries, what we call the Establishment Clause, began to limit the way in which, or at least the argument was for some of these institutions, ought to limit the scope of religious liberty protections afforded religious claimants. So we begin to see church and state worries as a limiting principle, at least so the argument went when it came to religious liberty. And yet another case, also from the 1980s, famous case, Bob Jones University, that had a policy of expelling students that engaged in interracial dating. And the IRS responded to this policy by pulling their tax-exempt status. This case goes all the way up to the Supreme Court, pits questions of racial discrimination against religious liberty, and it raised serious questions for the American Jewish community. How would they react to this case? On the one hand, there's quite a long story to tell about American Jews being denied access to higher education, questions of quotas within institutions of higher education, certainly great sympathies as a result within the American Jewish community when it came to the question of discriminatory policies within colleges and universities. Yet at the same time, one can certainly imagine the way in which American Jewish institutions might worry. Even if they didn't quite buy into this particular policy, what does it mean if a religious institution has an unpopular view? Does that mean they too can lose their tax-exempt status? What does this mean for minority religions as they tangle with majoritarian norms? And so you got to split again within the American Jewish community. institutions like the Anti-Defamation League and the American Jewish Committee, which is, hopefully you've gotten a sense, slide ever so gently on the progressive side of the ideological spectrum, found themselves filing briefs to support the IRS. And in their view, it was because there's simply a compelling government interest that overrides the religious liberty rights of the institution. By contrast, Culpa, which I've mentioned before, lives a little bit more on the ideological right, argued that the challenge here was simply giving the majority the right to impose its majoritarian norms on the minority when it came to religion was problematic and ought to trigger a religious liberty claim that should win the day. Bob Jones University loses the case, but hopefully, as you're getting a sense, you're seeing debates on the margins. Everyone agrees there's a claim here. Just we have these worries about the compelling government interest, in this case, racial discrimination in higher education. Is that enough to beat the claim? Nobody challenges the claim itself, but maybe there are limiting principles. This has changed, I would say, over the past 20 years. If somebody said to me, what does American Judaism think about religious liberty? What does that look like? As we enter the 21st century, what I would say is division. The division we began to see in the 80s has moved to the center of these debates. And that really happened, I would say, even in the late 1990s. And let me try to give you an example of what I have in mind. Asma already mentioned Hobby Lobby, the Hobby Lobby case from 2014, the question of the contraception mandate. Should employers be required as part of their obligation to provide health insurance to their employees to also provide certain forms of contraception, or should they be granted a Religious Freedom Restoration Act exemption? And here you had Jewish institutions lining up in a way you did not see in the 60s, 70s, 80s, and 90s. Here you had three views. One view was the institutions like Hobby Lobby should be supported. Their religious liberty claim should win the day. And you had some institutions like the American Jewish Committee, Jewish Council for Public Affairs, institutions that shade, as I mentioned, slightly more progressive, saying no, the rights of female employees to free contraception is too important. It ought to trump the religious liberty claim. It almost sounds again like the Bob Jones, the 1980s. Listen, you have a claim, but there are some things that ultimately we think, at least so the institutions thought, were more important. But for the first time, what you began to see is institutions arguing that there was no religious liberty claim at all. Why? Nobody's telling Hobby Lobby to use contraception. It's a corporation. A corporation can't use contraception. Their decision is simply too attenuated. It's too far down the causal, there's no causal nexus between what Hobby Lobby is doing and the use of contraception, even if they think it's sinful. They don't have to do anything. I've tried to bold some of the language from the amicus brief filed by the Anti-Defamation League and other institutions, questioning whether or not there was a sufficient ground to even identify a religious liberty claim. In Hobby Lobby, you also had many, many Jewish institutions that argued that, simply put, for-profit corporations ought not be granted religious liberty claims. It stands in stark contrast to what I mentioned in the 1960s when the Orthodox Jewish merchants filed suit. Those merchants were for-profit entities. And some of these same organizations back then supported the claims of the Orthodox Jewish merchants. Now, as you began to see these religious liberty rights tangling with the rights of others, some institutions made the move to say we have a bigger problem and we want to challenge the very religious liberty claim itself. It's a for-profit entity. We're not even going to balance. We ought not balance those rights against compelling government interests. There is no right there in the first place. I fear my time is growing short. I'm going to skip Masterpiece Cake Shop. Please forgive me. We'll do it next time. So where does this leave us right now? Let me try to say four quick things. First of all, we continue having, within the American Jewish community, ongoing divide over how to balance the rights of, when we talk about religious liberty claims, in what we might call culture war cases, cases that raise questions about women's rights, LGBT rights, etc., in the way that you kind of see in Hobby Lobby. And this debate is not simply about whether or not there's a limiting principle. Should we say the rights of the LGBT community, women's rights, are simply a compelling government interest that ought to win the day. But instead, there remains and continues to be divide within the American Jewish community, within debate between progressive and more traditionalist Jewish institutions, whether or not there's a religious liberty claim to begin with. I have an example of this, but as I mentioned, time is short. Second, there continues to be debate over the extent to which the Establishment Clause, separation of church and state, should be a limiting principle on religious liberty claims. And here I have in mind cases like Trinity Lutheran Free Comer, more recently Espinoza v. Montana Department of Revenue, whether or not the idea of excluding religious institutions from a government benefit or grant program available to private institutions across the board. Do states have the right to exclude religion? Is that, on the one hand, are you excluding religion in a way that targets religion, violates the free exercise clause? Or is the idea that government funding is going to religious institutions problematic, that undermines the principle of separation of church and state? And like I hopefully express in cases like Amos, the extent to which the Establishment Clause ought to be a limiting principle on religious liberty was debated in the 80s and continues to be debated today in these cases as well. And we'll skip this also. Third, this is to me maybe the most interesting piece of all of this. You know, I mentioned this divide, this growing divide, this polarization in many ways with the American Jewish community when it comes to religious liberty advocacy. A way in which maybe, as you might have noticed, it somewhat tracks the polarization we see more generally with respect to religious liberty in the United States. One area that it has not touched is questions of houses of worship and the ministerial exception. You know, there's growing case law. There's been case law for many years, and the Supreme Court addressed this in 2012 and most recently in 2020, whether or not houses of worship, when they employ religious either leaders or individuals within the institution who are important to its religious mission, can those institutions hire and fire in ways that don't necessarily comport with anti-discrimination law? Does an Orthodox Jewish synagogue that is committed to only hiring male rabbis, is it allowed to exclude female applicants from the applicant pool? In principle, you can't discriminate on the basis of sex and gender when it comes to hiring and firing. And yet we have a rule, the ministerial exception, that says when religious institutions engage in the hiring and firing of religious leaders, that is part of the protection afforded by the First Amendment. Now, you'd think you might have this may look like a battle again between questions of religious liberty and questions of anti-discrimination law, the protection of other minority groups. Here, interestingly, what we've seen in recent cases, certainly in 2020, is actually broad consensus within the American Jewish community, a worry that the idea that we would limit this category of who is and is not a religious leader, who does relate to the religious mission, an actual worry across the ideological and denominational spectrum that we need to broaden the category of who counts as a minister. And what's interesting about this, at least to me, is you see the pushback from American Jewish institutions about the idea that categories like minister ought to define who is and is not a religious leader. That instead, American Jewish institutions see their religious leadership coming in various types of institutions and from different kinds of people, and kind of majoritarian norms or majoritarian intuitions about who is and is not a religious leader actually don't track the American Jewish experience. And in that way, it fails to recognize, if we don't broaden the constitutional category of who is a minister, what we're ultimately doing is denying the theological experience of the American Jewish community. And that's gotten actually broad appeal within the Jewish community. I mention that because, you know, there's something built into that, some sort of intuition that, you know, at its core, what the American Jewish community, even as it continues to be divided regarding all these other different kinds of questions, when it comes to having its theological experience, the way in which it experiences religious leadership, the way in which it identifies which institutions provide religious meaning, that the idea that that experience wouldn't be recognized unites the Jewish community. I think that sounds right to me. That sounds right to me because, ultimately, at its core, a religious minority wants to have its leadership and its people and its institutions recognized. And it doesn't want its experience to have to track the experiences of others. Each community has a method of developing religious continuity, promoting religious experience that is different. And as a result, the one thing that really does continue, I think, to unite the Jewish community is making sure the law recognizes that as well. Thanks so much.
Many thanks, Avi. That very interesting review of the history of the jurisprudence, how the law has formed relating to the free exercise and establishment clause, as well as the Jewish experience. So it's so grateful. I think it's an interesting point to emphasize that not all traditions speak with a common voice. There often is varying opinions among the different groups, and I'm sure that's true of the Muslim and Native American experience, as well as many other faith groups as well. So very helpful. We've received a number of questions in the chat for each of you, and I'm just going to begin with a question for you, Asma, if you'll take this one. There were a number of questions relating to your point about empathy and how do we inculcate it? How do we grow or develop that empathy? And specifically, how do we develop and create more supportive interfaith communities along that principle?
Well, that's a great question. And I think, in my book, I spend much of it kind of laying out the problems that I see. But the solution section is always the hardest section, right? Everybody wants some easy answers. And I try my best in my book and the latest one that came out to provide some guidance on that. But mostly what I do in the book, I sort of mentioned this earlier in my talk as well, this framework of intergroup bias, right? And it's natural for us to be sort of separated out into our groups. It's a very human phenomenon, and there's nothing inherently bad about it. But I think what the point at which scientists have found that it becomes problematic is when one side feels threatened, right? And the way to then address that is to lower perceptions of threat, right? And we hear this a lot. President Biden, in his repeated calls for healing and unity, has said that we have to, quote unquote, lower the temperature. And that's another way of explaining this phenomenon of lowering people's perception of threat. If the in-group or a group does not feel threatened, they are less likely to react with hostility. And so in the book itself, I demonstrate that in the way that I talk about the concerns of conservative Christians. I'm like, there are very valid reasons for them to feel threatened. And I'm explaining that as just a very human phenomenon. It's not something peculiar. It's not something that, that's a problem for these people to be feeling. Any one of us, if we were in the same position, and different groups, different races and religions are in the same position in a number of other countries outside the US, and they react in the same way. And so the more we can kind of see the way someone's like acting and reacting as a human phenomenon, as opposed to just sort of like judging them on the surface and putting them into categories and then dismissing them, which unfortunately is what I see as the norm these days. I think that's the fundamental starting point, that just try to see them as human, try to understand where they're coming from like a genuine perspective, as opposed to just as a way of gathering information so that you can then offer a rebuttal. And so, it sounds pretty simple, but I think it's a pretty radical and important step that we have to take. And I think that first and foremost, as I do attempt my solution section, I point out that, look, we're in this hopelessly tribalized state of being, so many different types of polarization, but I fundamentally believe that religious polarization has to be different because it's about religion, and religion, of its very nature, is about trying to sort of figure out the truth and know that there's a higher source that knows the truth that you probably don't fully get, and you're just trying to figure it out in the course of your life. There's something sort of inherently fallible about humans that all religions teach, as I understand it, and I think that should make it different. It should teach us that we should have humility and hopefully just sort of like being tied to our traditions and understanding others as humans is an important starting point. And in the book itself, I get into a lot more detail.
Thank you. Avi or Mona, do you have any insight on how we build more supportive interfaith communities? Avi, let's start with you if you have any thoughts.
Asma's work on this is probably the gold standard on these issues. I think touching in is forcing people to recognize the way in which what they see tracks or similar to, at least from an experience perspective, what others see, even as the facts change and the circumstance change and the context change. I mean, that's the big hope. The hope is to remind people that what they're seeing now is what others saw then, and then trying to find common ground. I think the challenges that come up is obviously that works within religion. It's from the American Jewish communal perspective. Hopefully a little bit of what I said about Bob Jones University gives you a sense of the challenge or the struggle. That sometimes religious minorities see themselves as minorities in different ways. Their experience tracks. When they see a particular issue or a particular debate, tracks both parties in some way. And that sometimes generates very complicated, difficult conversations, not just kind of as they try to build, interfaith alliances, but also as they try to think about, who they are and who do they see themselves in. And those kinds of issues, they're hard. They're just genuinely hard. And that's why I think they persist in deep and important ways.
It seems to me that from both your comments that keys are not overreacting to threats, understanding each other, looking for empathy, making sure that we understand that there are lots of different viewpoints here and kind of weighing them out and trying to find the common grounds where we can and finding solutions. Mona, what thoughts do you have? And we just have a few more minutes here before the end of it. So if you could just give us a 30-second perspective, we'd love it.
Well, what I'm seeing here is there's a lot of ecumenical activity among the communities here, and so that the various denominations and religions come together and support one another and have dialogue. I think that's really important.
Great, thank you. So another question for the group. What kind of policy changes do you recommend? We're here where we are, and this is a big question, and because it covers lots of things, but are there one or two things that you recommend that we as a nation or a state, local groups can do to help promote religious freedom and better understanding in our communities? Mona, let's start with you.
Okay. Well, I've had a group and we discussed that. So it's we believe that part of that should be education, creating education and awareness. We believe in starting more at the local level and then expanding. And so that's the kind of work we're doing right now here in the Tucson area on the border. Feeling the border is part of that.
I love it. Starting local. I think so much of religious freedom and our experience is really just in the local. It happens in our schools and our businesses and how we interact with people in our daily lives. Thank you very much. Avi.
One thing that maybe came through in my presentation is, we're going to have debates over questions of religious liberty, but I certainly think those debates are better when we're not challenging the underlying claims that people make, the quality of their religious claims. This limiting principles we're going to be divided on. I think that's right. But when litigation generates the kinds of arguments that make us doubt the good faith claims of other religious communities, I think that's the kind of approach that really makes finding and building either policies or alliances going forward extremely difficult. It's another way of saying that not only do I like big-haired 80s music, but I also like American Jewish advocacy in the 80s more than I do in the present day.
Great, thank you. I think it's super important for all of us to take at face value the claims that are made and respect them and then work within that framework. Asma, what would you add?
So I agree with both Mona and Michael, or Avi, I should say. On the question of education and specifically about what religious freedom even means. I mean, my first book, When Islam is Not a Religion, spent a significant portion, just trying to explain to people what is religious freedom, because I think a lot of people think they know what it means, but they often sort of confuse it with something else, whether it be religious pluralism, or they think that when you're advocating religious freedom for all, that somehow you're saying that anything goes as long as you can justify it on the basis of religion. And it's like, no, there are, as Avi pointed out, limiting principles. And that's just like a basic thing that a lot of people, especially those who advocate against Muslims' rights, fail to realize. And I think also the philosophical roots of religious freedom, and this idea of the duty boundedness, the fact that the religious believers absolutely feel a duty to God in terms of like implementing the various sort of teachings of their faith. I think people forget that sometimes. I think it's just like a choice and like, whatever, you don't have to do that. And understanding that duty element and how religion plays an essential role in self-actualization and our understanding of ourself and the purpose of our life. And I think this also ties back, to conclude, to the earlier question of empathy, that if we can just see how each of us is on this quest for meaning and purpose in our life, that I think that radically changes, hopefully, the perception of things as a politicized issue to something that's very deeply human and deeply spiritual. Thank you.
Well, thanks to each of you. I have lots of other questions, and I wish we had more time to explore each of them with you and to get your perspectives on them. But I see that we have Scott here with us and back, so I think our time is up. Scott, we'll turn it back over to you.
Right. Well, and thank you, Matt and Asma and Mona and Avi. It's been just a remarkable session. I applaud you all. Thank you for sharing your time and your perspectives with us today.